Hi, everyone. I'm Ken Stern. I'm delighted to have you join us at another Bard Center for the Study of Hate webinar. And we're delighted today to have Amy Spitalnick, is how you pronounce it, with us, who is the head of Integrity for America, and she's going to talk about her a really important lawsuit. I want to give a little bit of a framing for this as we start. And then Amy will talk, and then we'll do question and answers, which I'll moderate at the end, and I'll remind people about how to do that. So the question of law and hate and the interaction between the two has always been something of interest to me, and it's something of interest to the Bard Center for the Study of Hate. I mean, law on one hand has been a tool for promoting hatred and discrimination and demonization. But on the other hand, it's also been a useful tool to combat hatred as well. Some of you may be old enough to remember the idea of using civil suits to redress violent hatred. The first I remember was actually the attempt when Leon Klinghoffer, who was a Jewish gentleman in a wheelchair on a ship, was thrown overboard in a terrorist attack, and there was an attempt to sue people for that, which was harder in some ways because it was a foreign entity and so forth. But we saw a real number of attempts over the years, successful attempts, to go after people that promoted hatred that may have had criminal liability, may have not, but civil actions as well, to really cause them to pay literally for what they did, and to sometimes compensate people that directly who were the victims. The first I remember that was the Southern Poverty Law Center going after a Klan group and basically shutting them down, getting the building, turning it over to the family of a person they had killed. There was also a very interesting lawsuit years ago in Portland, Oregon, when an Ethiopian immigrant was killed by a bunch of skinheads in East Side White Pride. And there was a lawsuit against a guy named Tom Metzger, who was the head of something called White Aryan Resistance. And there was some question about it. Well, this is a neo-Nazi group, but they're just advocating. But they were able to show more than just political statements, and as hard as they would be, things that were protected speech. They showed basically, in that case, that to get in the upper echelons of this organization, people were being told you had to beat up people of color. And that's precisely what happened, and that's why they were held liable. Some of you may remember that for many years there was the Aryan Nations in northern Idaho and Hayden Lake, and they were responsible for a lot of hateful violence, killing talk show host Alan Berg, robbing banks, the group The Order, Buford Furrow, who shot up the Jewish Community Center in LA in the late 90s, was there. And there was a bunch of people that were talking about, what should we do about this? Is there a legal remedy here? And somebody came up with the idea of, let's do a suit for a nuisance, as if you had a toxic dump at your neighbor's backyard. Is there a way of using those types of laws to shut it down? And I and others said we're really cautious about that, because it was a question of speech in some ways. It was a question of association. And to bring a case like this, you really, because it's such an important case, and a case that is an educational model, you had to be sure, as much as one can be, that you were actually going to win. And eventually what happened is there was a group of guards who shot up somebody's car, and so you didn't have to worry about association or nuisance. You had the bullets and the bullet holes, and could make the case, and they did. And they shut the SPLC, and a local attorney named Norm Gissel, who's an unsung hero of these battles, really shut that down. So with this background, I was delighted to see, in the aftermath of what we all saw at Charlottesville, Amy and her group step up to file a lawsuit here. It's important. It's an educational opportunity. It will hold a lot of these people accountable. And Amy will walk you through what the case is about and its implications. I do want to share one thing before I introduce you, Amy, is that Amy shared with me a bunch of resources, which I will follow up in an email with everybody tomorrow. And one of them is 3 clips from Rachel Maddow talking about the history of these types of lawsuits. And Rachel at one point sort of opined, well, gee, we really haven't progressed much in 20 years since the Aryan Nations lawsuit. Here we are again. I would sort of think of it the other way, in that Amy's suit is much more complex than the ones that we saw in the past. It's not like there's just one group that you're going after. This is a combination of groups. They're more varied. It's not like going after a KKK compound or the Aryan Nations. And we're dealing in a different time, in a political environment where all these groups seem emboldened because you have political leadership that's saying things that they find inspiring. So I think it's a much more difficult time for this type of a lawsuit. I think it's a much more important time for this type of a lawsuit. And that's why I'm delighted that Amy is going to share the experiences of this case and what the status and what we hope to achieve with you all. As I mentioned at the end of Amy's presentation, I encourage people to put questions, type them in the Q&A box. I will moderate those and ask Amy the questions, and we'll keep this exactly as an hour. So let me give a brief introduction of Amy, and then Amy, I'll turn it over to you. So Amy is over a decade of experience in government politics and advocacy. She most recently served as a communications director and senior policy advisor to the New York Attorney General. She has served as an advisor and spokesperson for the New York City Mayor, communications director in the New York State Senate, and on a number of federal, state, city and state 40 under 40 Rising Star in 2013, and she's a graduate of Tufts University. Amy, we're delighted to have you with us today.
Thank you so much, Ken. And thank you to everyone who took the time to join. Before we dive in, I'm going to share my screen to show a brief video on Charlottesville and specifically our case, to give you a sense of a little refresher of what happened 3 years ago. It was exactly 3 years ago last month that the violence unfolded. And then I will give you a rundown of our work, of where the case stands, of the legal theory behind it, and how it fits into the broader cycle of far-right extremist violence that we've seen in recent years. But I really do want to make sure this is as conversational as possible, especially given the topic. It is a heavy one. And so I will try to keep my presentation as short as possible, and so that we could really turn to questions and discussion as soon as we possibly can. But as I said, to get started, I'll share my screen and show this brief video. I should warn people, there are some disturbing images and sounds in the video of what happened 3 years ago. We do like to warn people of that. Unfortunately, it is a reality of this topic. And without further ado, let me share my screen. Here. Who's free? I'm free! Who's free? I'm free! Who's free? I'm free!
Terror in Charlottesville. Stark displays of racism.
To promote a car has rammed into a crowd.
Victims thrown in the air.
React to domestic terror.
10 of the people who were injured in Charlottesville, including 3 of the people who were hit by that car and survived, have now brought a lawsuit against not only the murderer who drove his vehicle into the crowd, but also the leaders of all of the white nationalist groups that organized and promoted the Charlottesville event.
We are Integrity First for America. We are here to disrupt the extremism, to interrupt the cycle, to dismantle and bankrupt these hate groups and their leaders, to put them out of business, and most importantly, to stop the violence. Integrity First for America is leading the fight against white supremacy. Our Charlottesville lawsuit is the only current legal effort taking on the broad leadership of this movement, holding white supremacists accountable for their premeditated violence. We know that it's working, They're already facing huge financial and legal consequences. But we also know what we're up against. Bankrupting Nazis isn't cheap. These groups are still recruiting, weaponizing fear, and preparing for their next attack. Now more than ever, we are reminded of our obligation to dismantle the systems of white supremacy that poison this country. Turn your outrage into action, because hate has no place here.
I feel like I always need to take sort of a deep breath after we show that video. It's so easy to forget these days, especially in the news cycle in which we live, that 3 years ago, an American city was targeted by neo-Nazis and white supremacists for a weekend of violence. An American city was directly attacked by these violent extremists. And what's so important to understand about all of that, as that video alluded to, is that nothing was an accident, but rather the violence that unfolded in Charlottesville 3 years ago was a meticulously planned, racist, violent conspiracy. And it's that conspiracy that is the basis of our lawsuit. But before we dive into the case itself, I think it's worth taking a step back and reminding people of exactly what happened 3 years ago. First, many of us vividly remember the images of that Tiki Torch March on the University of Virginia, where these neo-Nazis and white supremacists wearing matching uniforms of polos and khakis, carrying matching tiki torches, descended on the University of Virginia campus and ultimately surrounded a small group of peaceful counter-protesters at the Thomas Jefferson statue in the center of what's called in the center of No Name Field. There, they ultimately started chanting things like "Jews will not replace us," "blood and soil," throwing fuel and lit torches on the counter-protesters, beating them up, kicking them, punching them. One of our plaintiffs who was there that evening, an African-American undergrad at UVA, said he thought he was going to die that night. Nearby, a number of interfaith communities and leaders had gathered for a vigil, for essentially an interfaith service that was meant to give people a safe place to gather ahead of what they expected to be a horrifying weekend in their town, knowing that these white supremacists were coming for the Unite the Right rally. They ultimately had to shelter in place because it was too unsafe for them to leave the gathering with the neo-Nazis and white supremacists descending on UVA just a few blocks away. Of course, the next day was sadly no less violent and much more tragic. We know that, of course, so much after the fact about what went into the planning, which I'll get to in a moment. But Saturday, August 12th was the day that these white supremacists intended to host this Unite the Right rally under the guise of protesting the removal of the Robert E. Lee statue from what's now called Emancipation Park in downtown Charlottesville. As I'll talk about in a second, that was simply a guise. The point of this all was always violence and always to target people based on their race and their religion and their willingness to defend the rights of others. But we do know how that day unfolded, and it was as horrific as it was 3 years ago to recount it. First, these neo-Nazis and white supremacists descended on downtown Charlottesville. It was a Saturday morning, so the small local synagogue was celebrating Shabbat. They had already changed the time of services in hopes of avoiding some of the violence and the crowds. The neo-Nazis ultimately surrounded the local synagogue, chanting things like Sieg Heil, talking in their online chats about, quote, torching those Jewish monsters. And the synagogue, which was home to a scroll that had been saved from Nazi Germany decades ago, had to evacuate its congregants out the back, evacuate Torahs. And the detail that always gets me every single time I tell the story and read it in our lawsuit is the fact that this Torah that had been saved from Nazi Germany decades ago was once again under Nazi threat in America in 2017. And that just gets me every time. Of course, the violence continued throughout the day. You saw one of our plaintiffs, Reverend Seth Wispelway, in that video. He and his fellow clergy members had been peacefully marching, protesting the white supremacists in their town. Seth was attacked by a number of our defendants and their supporters and injured. And of course, we know how the day ultimately culminated, with James Fields driving his car into a crowd of peaceful counter-protesters, killing Heather Heyer, injuring many others, including many of our plaintiffs, some of whom you can see in that iconic Pulitzer photo of the car hitting the crowd. And I'll talk about our plaintiffs in just a moment. But what's so important to understand about all of this, as I mentioned, is that nothing was an accident. Rather, for months in advance on social media platforms, including on a site called Discord, which is typically used by video gamers to communicate while they're playing video games, these neo-Nazis and white supremacists planned every last detail. They talked about the banal, so what to wear, what to bring for lunch, will mayonnaise spoil in the sun, what's the best gluten-free bread to get. When you think about the banality of evil, this was truly it. And of course, they talked about the vile and the violent, the best way to sew a swastika onto a flag, how they could use their quote unquote free speech instruments as violent weapons, like flagpoles, for example, and even discussions of whether they could hit protesters with cars and then claim self-defense, which is of course exactly what they did. And so, on behalf of a coalition of Charlottesville community members who were injured in the violence, we are supporting this lawsuit that takes on the 24 individuals and hate groups directly responsible for organizing and executing the violence. There were hundreds and hundreds of extremists in Charlottesville in August of 2017. What our lawsuit does, using the Discord chats and other evidence that we've collected, and were frankly released out into the world in the aftermath of the violence. We had a lucky break early on. A nonprofit journalism outfit called Unicorn Riot released leaked Discord chats within days of the Unite the Right violence that ultimately became the basis of our suit. We've of course since subpoenaed them in a way that's usable for trial, but these chats make crystal clear the planning that I described earlier, and also made clear who the direct ringleaders were responsible for orchestrating what happened. And our suit specifically takes on those who orchestrated and organized this violence, who were the direct individuals and groups responsible for the violent conspiracy that I just detailed. We are suing them under a number of civil rights and state and federal statutes. The one that is always most of interest is something called the Ku Klux Klan Act of 1871, which was first passed nearly 150 years ago by the Reconstructionist Congress to protect recently freed slaves from Klan vigilantes in the South who were seeking to undermine their 13th, 14th, and 15th Amendment rights through violence, through terror. And it has been used a number of times since, including, as Ken mentioned earlier, during the series of civil rights cases that came about for both the Freedom Rider era through the 80s and 90s. In particular, there's a case called Griffin V Breckenridge that deals with a racist, violent conspiracy and assault that took place, I believe, in the late 60s. The case was heard in the early 70s. That uses the statute, and I think is exactly illustrative of just how relevant it is here in some ways. We talked about how it feels like we haven't come very far, but in other ways we have come very far. And that's exactly right. In this case, you can see firsthand both how far we've come in terms of the fact that there were people who were willing to stand up for their communities, stand up for their rights in Charlottesville, and they were attacked for that, which is horrifying and depressing. And there were extremists who used social media to plan violence against these people in advance. The fact that we have those chats, the fact that those chats are the basis for our lawsuit, as I described, I think is both stunning and really illustrative of the broader challenges and issues at hand. And in so many ways, when you think about the evolution of extremism, we are no longer dealing with Klansmen in white hoods in the South, in the woods, conspiring as they might have done in the late 1800s and early 1900s when the KKK Act was first passed and used. Rather, they are now meeting on social media, conspiring there and bringing that violence out into the real world. And I'll talk in a second about the sort of broader cycle of white supremacist violence that is directly connected to what happened in Charlottesville. But suffice it to say, the ways in which social media has become essentially the Klan den of the 21st century is so perfectly encapsulated in this case, and also gives us evidence in the form of these chats and other planning communications that make crystal clear the racist, violent conspiracy that happened in Charlottesville 3 years ago. There's so much more to say about the KKK Act and about the case itself. I will just want to quickly run through where our case stands, who our defendants and plaintiffs are, and how it fits into the broader cycle of extremist violence that we're currently facing, not just nationally, but globally, and then really open it up to questions. It is fall 2020, which means that it has been 3 years next month that since we filed this case originally. Justice is not fast by any means, and COVID has certainly made it slower, which is an unfortunate reality of the world that we are living in now. Our trial was originally scheduled for next month, for October. It now looks like it will be held in spring, in April of 2021, which is not too far away, and we are working with the court to ensure safety measures are put in place, and that we can do a jury trial in Charlottesville safely during COVID and hold these extremists accountable in front of a jury of their peers. But putting aside the fact that we have not yet gotten to trial, it's also important to understand that the accountability and the justice and the impact that this case has been able to make even before we get to trial, which is heartening. In July of 2018, the court issued a really well-written and I think worth reading decision rejecting the defendant's motions to dismiss this case. It's on our website. We'll also make sure to include it in the follow-up email that gets sent out. And that decision rejects the arguments made by the defendants that their conduct and their violence was somehow protected by the First Amendment or the Second Amendment. The judge makes crystal clear that the First Amendment does not protect their right to commit violence, which you would think is a no-brainer, but it was central to their argument in the motions to dismiss, and we suspect will be central to their argument at trial. Since then, we have been in what's called discovery, which means evidence collection, essentially, not just collecting evidence through subpoenas, through document review, in this case, specifically collecting documents and other evidence off of the defendant's phones, computers, social media, and email accounts, but also deposing them. We have a whole team of lawyers whose job it is to quite literally depose Nazis, which I think is going to be an extraordinary story for them to share with their children one day. Despite how long it has been since we first filed this case, we have also seen very real impacts over the course of the 3 years. Most notably, we have been able to win major financial sanctions and other penalties against the defendants, holding them accountable for repeatedly trying to flout court orders and their discovery obligations. Just a few months ago, we won over $41,000 in sanctions against 3 key neo-Nazi defendants. Earlier this year, one defendant, Elliot Klein, who is one of the 2 lead organizers of Unite the Right, was thrown in jail for contempt of court. And actually just yesterday in court, another defendant, Robert Asimdor Ray, who's a major neo-Nazi podcaster and a central player on the Daily Stormer, where he helped organize the Unite the Right violence, was also found in contempt of court, and the court is issuing a bench warrant for his arrest, which we expect to happen imminently. So even before we get to trial, we have seen very real consequences. We've had defendants like Richard Spencer complain that this case is quote unquote financially crippling. Others like League of the South, a neo-Confederate hate group and a defendant in the suit, have talked about how they can't open a new building as a result of our suit. Others have tried to rebrand, like Identity Europa, which is a white supremacist group that now goes by American Identity Movement. Vanguard America has tried to rebrand as Patriot Front. And some defendants have even claimed that they're leaving the white supremacist movement. There is, of course, deep skepticism around this, and many experts in extremism have pointed out how convenient their reform is to the fact that they started facing accountability in this lawsuit after decades in the movement. And we think, of course, if they were truly seeking to reform, they would fully cooperate with our suit, but that is another story for another day. Suffice it to say, we believe that, and we've seen firsthand how this case has made a very real impact on the ability of the defendants to operate and in terms of holding them accountable legally and financially. Before I wrap up and we open this up to questions and discussion, I just want to discuss 2 other quick things. Who are our plaintiffs? And I think our plaintiffs truly are the most brave, the bravest, just incredibly brave people who have taken this awful thing that happened to them and channeled it into this lawsuit, which is not the easiest path but is the one that will have the most impact, not just for their community and for the justice and accountability they so deserve, but for this country. Our plaintiffs include people like Marcus Martin and Marissa Blair. Marcus, you can see in that iconic Pulitzer-winning photo of the car hitting the crowd. He's the African-American man splayed across the back. His then fiancee, now wife Marissa, he had just pushed out of the way, saving her life. Marissa and Marcus were there actually with Heather Heyer, who was Marissa's colleague. They were paralegals together. Other plaintiffs include Thomas Baker, who's seen in that photo flipping over the hood of the car, Natalie Romero, whose skull was fractured in the car attack, and a number of others who were injured both during the car attack itself and during the tiki torch and other violence throughout the weekend. They are incredibly brave. They are Charlottesville community members of all backgrounds and walks of life, students, clergy, young professionals, who have chosen to take, again, this awful thing that happened to them and channel it into something that will have incredibly real impact for their community and for their country. The defendants are truly a who's who of this violent movement. I listed some of them earlier in describing the case's impact, but I suspect many of you will know their names. People like Richard Spencer, who coined the term alt-right and is perhaps one of the country's most famous neo-Nazis. Groups like Vanguard America, Identity Europa, National Socialist Movement, which is the country's largest neo-Nazi group currently, League of the South, a number of Ku Klux Klan groups, and other individuals like Chris Cantwell, Augustus Invictus, and many others, Matthew Heimbach, and many others who are really at the center of this broader movement. And that gets to the crux of why this case matters and why it matters so much. Of course, this case is ultimately about justice for our plaintiffs and accountability for those responsible for the violent conspiracy in Charlottesville 3 years ago. There has been so little accountability in the aftermath of Charlottesville, and this case is the only effort to hold accountable the broad leadership of that racist, violent conspiracy. Of course, it is about that justice and accountability, but because our defendants are at the center of this broader violent movement, this case will have impacts that extend well beyond Charlottesville. We know that our defendants are at the center of this movement because we've seen it sadly firsthand over the last few years. We know, for example, that the Pittsburgh shooter communicated with some of the Charlottesville leaders before killing 11 at Tree of Life Synagogue in Pittsburgh almost 2 years ago. We know that the Christchurch shooter, who killed dozens of Muslims praying at mosque in New Zealand last year, painted onto his gun a white power symbol that was first popularized by one of our defendants. And Christchurch, in turn, inspired the Poway attack and the El Paso attack last year. And even during both the coronavirus pandemic and the Black Lives Matter protests, we've seen firsthand how central these defendants continue to be to the broader movement. During the beginning of the coronavirus pandemic, there were reports of a neo-Nazi who tried to bomb a hospital in Missouri that was treating coronavirus patients. That man was a member of National Socialist Movement, one of our defendants in our lawsuit. Similarly, as the protests got off the ground this summer, we saw, for example, white supremacist group Identity Europa pose as Antifa on Twitter, urging looting and violence in white neighborhoods in hopes of spurring violence and having armed men show up to, quote unquote, fight the Antifa threat, which is, of course, exactly what happened. And similarly, many of us have watched the horrifying rise in car attacks as a tactic of these white supremacists and other far-right extremists, oftentimes targeted at Black Lives Matter protesters and others. And it is not an accident that car attacks have skyrocketed in recent months, targeted at protesters. It is a tactic that was used firsthand in Charlottesville and has been used over and over again, oftentimes fueled by the same sorts of online memes we saw in the Charlottesville planning chats. So I will wrap things up there and leave it by saying that we are truly dealing with a horrific cycle of far-right extremist violence in this country. I don't need to tell any of you just how serious this threat is. Sadly, the last couple of weeks have only made it ever more clear, with extremists like Kyle Rittenhouse so emboldened that they feel that they could walk out onto the street and kill 2 people in cold blood and then be lionized by not just the white supremacist leaders of the broader movement, including many of our defendants, but by right-wing pundits and leaders. And it is part of this broader cycle that we take on directly through this lawsuit. As Ken mentioned, by this is not a new strategy. There is a long, important history of cases that take on through civil lawsuits, through winning large civil judgments, as we intend to do at trial, the finances and the resources of these hate groups and these leaders. In this case, when we win large civil judgments at trial, and as we already have with the sanctions and other financial penalties we've won even before we get to trial, can fundamentally bankrupt and dismantle the groups and the leaders that are at the center of this movement and have an impact that goes well beyond Charlottesville and sends a crystal clear message that if you are part of these racist, violent conspiracies, you will face very real consequences for your action. So I'm going to leave it there for now. I'm happy to answer any questions about the case, about the broader cycle of violence that and our defendants' disturbing connections to it, and about so much else that is happening that is all deeply interrelated, and that in so many ways Charlottesville really served as the harbinger of the preview of, in terms of the tools and tactics these extremists use.
Great. Thank you, Amy, so much for that overview. I am going to ask people to put in questions. I said we have 3 already. I will turn off my video, but ask the questions for you so people can see just you as you answer. But I wanted to ask you one question first, just to build on some of the last things that you were saying. Following COVID and some of the protests again and the Black Lives Matter protests and so forth, we've seen other groups too, Proud Boys, Boogaloo, some of the malicious folks. I'm curious if you've picked up any chatter of what they've said about your lawsuit, if anything. So I'll let you answer that, and then I'll ask you other people's questions.
It's a good question. It is really a fascinating time to be doing this work and to be thinking about these groups, because the proliferation of these groups and the different ideologies within them in the last few months even is stunning. And so Ken mentioned the Boogaloo Boys and the Proud Boys. There are traditional white supremacist groups like the neo-Nazi groups like the ones we are taking on in the suit. There are also these militia groups in the so-called Boogaloo Boys, some of whom identify as white supremacists, some of whom will claim that they are not, that they actually support the protesters and oppose government and police. The ideologies within these groups are incredible and varying, but at the end of the day, I think it's important that we not lose sight of how connected they all are as part of this broader rise of far-right extremism, whether it be explicit white supremacy, whether it be vigilante militias, and other extremists along those lines who are vehemently anti-government and pro-gun, and otherwise. And we, on our website at integrityfirstforamerica.org, we've been tracking the various ways these groups and these extremists have been trying to exploit the protests over the last few months to further their horrible ideologies, in some cases pure white supremacy, in other cases anti-government, in many cases both. And it's where these groups overlap that I think, Charlottesville really is a perfect example of. Those who came out in Charlottesville represent both traditional neo-Nazi and white supremacist groups and many of the militia groups that continue to crop up, some of them in new forms, some of them in the same form over the last few years. And what's been most fascinating over the last few weeks has been to watch how the defendants in our lawsuit and their supporters are seeing what's happening, seeing individuals like Kyle Rittenhouse lionizing them and holding them up as an example of why their actions are so important. It's how it is, they see him as exactly in line with what they did in Charlottesville. They argue that he, like they, were acting in self-defense. And it is truly horrific and stunning and totally unsurprising. We have seen, there are certainly extremists from the Proud Boys, from militia groups who have been chatting about our case and the broader dynamics at play here on the dark web. Many of them do so anonymously. So it's hard to know exactly where in this sort of far right movement they fall in terms of official affiliation, to the extent there is official affiliation. But there is a lot of chatter about the case and about the defendants in our case, and how both from a sort of holding it up as using it oftentimes as an attempt to fundraise, but also at the same time as sort of a cautionary tale for them. We've seen direct chatter of them saying, well, we're not going to do this because we don't want to be sued like the Unite the Right leaders. They don't say it in that exact term, but we've seen them explicitly talk about the fact that they do not want to be sued like the defendants in our suit, which I think is important and illustrates the deterrent effect a case like this can have.
Okay, thank you, Amy. I'm going to combine two questions into one, or actually link them together. One is, what are the possible legal consequences if the defendants are found guilty? And the second is there any way winning these civil lawsuits can be used to bring criminal charges against them?
Yeah, I think I might start with the second question just because it underscores the importance of this case. If we were living in a different period of time and Charlottesville happened, and I don't know if something like Charlottesville would have happened in a different time period, but let's play hypotheticals. If something like Charlottesville happened during, say, the Obama administration, I suspect the Department of Justice's Civil Rights Division would be all over what happened in terms of bringing the types of cases that they have the ability to bring in circumstances like this. Some cases that might be very similar to ours, but would have criminal jurisdiction because they were being brought by a prosecutor, which we as private plaintiffs can't do, as private litigants can't do. And so, you know, whether or not there are ultimately, there's ultimately some sort of criminal conspiracy case that's brought here, I'm not particularly optimistic. That being said, there have been a handful of smaller criminal cases brought against some of our defendants and some of the other Unite the Right participants. Most notably, of course, James Fields is in prison for the rest of his life for killing Heather Heyer during the car attack, but a number of others, including some of our defendants, have been charged with various forms of assault and other criminal charges as a result of their actions. However, there has been no case that has held accountable the broad leadership responsible for orchestrating the conspiracy, and that is what our case is all about. So whether or not someone ultimately chooses to bring additional broader criminal charges here, we believe that the lack of accountability since Unite the Right 3 years ago only underscores the urgency of our case, even more so in this period of time when we have a Department of Justice and a Civil Rights Division that seems, to put it lightly, disinterested in civil rights. And sadly, the stats tend to back that up. As we know, DOJ civil rights investigations are down nearly 2/3 compared to a few years ago. The first question about the potential legal consequences if the jury finds the defendants guilty. This is a civil case. And so ultimately the consequences here really are about financial penalties and injunctive relief, and financial penalties being the crux of this. And as Ken described earlier, and I would encourage people to watch the Rachel Maddow clips that will circulate in the follow-up email, because I think they really do a great job of illustrating the history of some of these cases. Financial penalties can have a major impact on the ability of these hate groups and their leaders to operate. We saw it firsthand. We talked about the Michael Donald case, which was brought by the mother of a victim of Klan violence in the South, represented by the SPLC. And ultimately, the mother of that victim won the title to the Klan's Tuscaloosa headquarters and effectively bankrupted the organization and put them out of business. And that is not the only case that has worked this way. There is strong precedent of cases. I mentioned Griffin V Breckenridge, which is a case in which the exact statute we're using, the Ku Klux Klan Act of 1871, was used. A number of other cases that were brought, especially during the 80s and 90s, against Klansmen and other, the Aryan Nation and other far-right extremists, seeking to hold them accountable through civil measures for their violence and for their other sort of their roles in this sort of violent hate. One case that is not directly related to white supremacy, but that I know our legal team thinks about quite often here, is a case brought in the 90s against a website and its leaders. The website was called the Nuremberg Files. And this was a site where far-right extremists who were targeting reproductive health clinics and professionals would list the names, photos, addresses, and other information for these doctors and other staff members, and then put a red X through them every time one of them was injured or in some cases even killed. A number of reproductive health providers brought a lawsuit represented by Marty London at Paul Weiss, who is a former colleague of one of our lead attorneys, Robbie Kaplan. And in that lawsuit, while it was brought under slightly different statutes than ours, the theory, the ability to use these civil judgments to effectively bankrupt and put out of business these hate groups and these violent extremists is very comparable. And in this Nuremberg trial suit, they used these civil judgments to effectively bankrupt the Nuremberg Files and its leaders. And while there certainly continues to be violence related to reproductive health, I think there has not been that level of extremist violence targeted at reproductive health clinics and professionals as we saw in the 90s. And it's in no small part thanks to this case. And what they did was effectively chase these leaders around for the rest of their lives, garnishing their wages, putting liens on their home, collecting anything that they ever earned and raised, and held them accountable through those civil suits. And that is exactly what our legal team is going to do here, that when we win these large civil judgments, we will chase them around for the rest of their lives to ensure that anything they own, anything they earn, any home they have has a lien put on it, to hold them accountable and ensure that they pay the judgments that we expect to win at trial.
Great, thank you. So next question is, can you give me a way to get information about the infiltration by the alt-right into the Black Lives Matter protests to undermine the BLM movement?
So on our website at integrityfirstforamerica.org, we have been tracking the various ways white supremacists, Boogaloo Boys, militias, and other far-right extremists have tried to exploit the protests. In some cases, it's been, as the questioner described, explicit attempts to pose as Black Lives Matter protests, pose as quote-unquote Antifa, and use that as a means to spur violence and terror, and other attempts to undermine the message of the Black Lives Matter protests. I mentioned earlier our defendants, Identity Europa, posing as Antifa in a fake viral tweet, which sought to sow violence in white neighborhoods and have armed extremists show up to effectively defend against the Antifa threat that didn't exist. This is the same sort of tactic we've seen over and over again, using disinformation, using duplicity as an attempt to sow violence and terror and distract from the actual issues at hand, which in this case is racial justice and far-right extremism. Similarly, there have been various attempts by militia members, by Boogaloo Boys, some of whom have been prosecuted to try to incite violence at protests. A few Boogaloo Boys were arrested for trying to incite violence at BLM protests in Las Vegas earlier this summer. Others are just explicitly and horrifically targeting protesters themselves, whether it be car attacks against protesters, as I described earlier. For example, in Richmond, Virginia, an avowed KKK leader plowed his car into Black Lives Matter protesters in June. He was just sentenced to 6 years in jail. Thankfully, no one was killed, but Richmond is just down the road from Charlottesville. Gives you a good sense of how these sorts of tactics continue to proliferate. Others, like Boogaloo Boys, who are sort of a unique subset of the broader extremist and militia movement, who seek to essentially spur a second civil war and are vehemently anti-government and pro-gun, have in some cases directly targeted law enforcement, killing two members of law enforcement in California earlier this summer. Others, two Boogaloo Boys were just arrested, I believe, last week for seeking to coordinate with Hamas, which is truly sort of like a mind-boggling confluence of extremism. And so it really varies. There are some that are directly trying to pose as Black Lives Matter and Antifa in hopes of spurring violence and distracting from the protests, and some who are directly using the protests to target protesters, target law enforcement and others with their violence.
Right, thank you. The next question is, given the well-documented incompetence of local and state police, as well as UVA leadership on August 11th and August 12th, as well as the mismanaged communications of Maurice Jones, then city manager, and the since fired chief of police, and given that police opened 4th Street to traffic after the quote rally, how is your case being constructed to keep accountability on the perpetrators exclusively? Parenthetically, the person who asked this said, I was a newspaper editor in Charlottesville for 17 years until recently and appreciate all you're doing. And let me add one thing on to that. So I anticipate that part of the defense ought to be, it wasn't us, it was bad policing.
Yeah. That question, before you even read the parenthetical at the end, I suspected that question had to come from someone in Charlottesville. And it is a good question. And you are exactly right that this is something the defendants will certainly try to argue. And none of that matters, because at the end of the day, as I described earlier, the defendants went to Charlottesville after planning for months in advance a weekend of violence. And if you look at the Discord chats, and I encourage folks to check out our complaint, which is on our website, and we can also include in the follow-up email, it makes crystal clear that no matter what the police did, no matter what UVA did, no matter what the city manager did, the intent was to bring violence to Charlottesville, to target people based on their race, their religion, and their willingness to defend the rights of others. And that is exactly what they did. So no matter what happened, no matter what else happened in terms of what law enforcement did, in terms of what the university did, that was the defendant's intention. And as we saw play out, that is exactly what they did. And so there are certainly other efforts to hold accountable other stakeholders in that weekend, other lawsuits, other litigation, that some of which continues to play out. Our case is specifically about the 24 individuals and groups that planned violence and that went to Charlottesville to commit violence. And that has been made crystal clear in our lawsuit. That is something that some of the defendants tried to argue in their motions to dismiss the case. And as I mentioned earlier, the court squarely rejected the defendants' motions to dismiss. And while we expect them to argue it at trial, as Ken suggested, we are confident that a jury will see exactly what they intended to do, how meticulously planned it was. And then, of course, what unfolded over August 11th and 12th, 2017 was directly the result of that planning and had nothing to do with what a police officer might have done, a university might have done, and would have happened regardless of any of those outstanding factors.
Great, thank you. The next question is, and have a drink of water if you need. Is Discord being charged for providing the platform for these white supremacist group? How about other social media?
A good question, and one that I think is not just relevant to this conversation here, but to the broader conversation around social media and extremism that's happening in this country and that we so desperately need. Specifically to this case, our plaintiffs, or rather our defendants, are the 24 individuals and groups that, using social media and other platforms, planned the violence and then executed the violence. That's who we are focused on. That being said, even if we wanted to take legal action against Discord and other social media sites, currently under federal law, there is very, very little liability for social media companies for what happens on their platform. There's something called the Communications Decency Act, specifically Section 230, which provides essentially a cover to social media sites for anything that happens on their platform, so that they can't be held liable if, say, for example, their platform is used to plan violence or share other violent, extremists, lewd, whatever content. Section 230 was, of course, originally conceived of to essentially protect platforms from taking action to remove things like porn and other lewd content. Of course, now at a time when we see both traditional social media sites and sort of extremist sites like 4chan, Gab, and Telegram essentially being co-opted by extremists, it's providing essentially a shield to any sort of regulation or legal action that might be taken in these cases. all of this is to say, I think it is impossible to understand the rise of violent extremism in America without looking at the role of social media. Certainly in Charlottesville, where Discord and other platforms were where the violence were explicitly planned for months in advance, as I described. But of course, in the cycle of violence that's followed, in which using social media channels, these extremists have used each attack to inspire the next one, including, for example, Christchurch, which was seemingly inspired by a number of prior white supremacist attacks, where a defendant in our suit popularized the white power symbol that was painted onto the Christchurch shooter's gun. And in turn, the Christchurch shooter used Facebook to live stream his attack, and his attack in turn inspired others like Poway and El Paso. So understanding the direct role of social media and their obligation to do something about it, no social media company is obligated to give a platform to extremism and to violence, period. The First Amendment does not apply to Facebook or Instagram or Telegram or Discord's terms of services. They have no obligation to give a platform to this extremism, and the fact that so many of them are unwilling to do something about this gives you a sense of where their priorities lie, to put it politely. And I do strongly believe that we need to have a serious conversation about how we, from a regulatory perspective and a public policy perspective, about how we are going to continue to take action here, so that we're not simply catching up after the fact, which is exactly what happened in Charlottesville. These extremists were able to plan violence on Discord for months in advance. No one seemed to have caught it. The chats were leaked after the violence unfolded, which was too late. And while they are incredible evidence in our lawsuit, I wish we never had to bring this lawsuit in the first place.
Thank you, Amy. I'm going to combine two questions that may not at first glance seem related, but I think that they will be, and I want to get to as many questions as we can. One is a report released by the Network Contagion Research Institute yesterday concluded that violent memes and messages have been surging on the far left social media. Have you seen that? And again, looking at this from the flip side, a question is, as I recall, Southern state governments tried to use similar suits to bankrupt civil rights groups in the 50s and 60s when racists controlled state government. Should we worry about something like that being used by the right now? In other words, how's the other side using it? Can the tool you're using be used against progressive groups?
Yeah. To start with the first question, I think that there is a lot of whataboutism and both sidesisms, which is not a real word, but one that describes what we're doing, which makes the point I'm trying to make here. I think there's a lot of that happening, and that doesn't mean that there isn't violence on the left, but it's so important to understand where the greatest threat lies. We know that right-wing extremists killed more people in 2018 than any year since 1995, which was the year of the Oklahoma City bombing. There was a report that came out just a few months ago from CSIS that made clear that anti-fascists were responsible for quite literally 0 murders over the last 25 years. Of course, there's the now famous case in Portland and seemingly the potential extrajudicial killing of the suspect in that case, which we learned more about this week. So all of that is to say there is certainly violence on the left, but it is not the sort of violence that is incredibly organized and planned and coordinated in the way that we have seen in Charlottesville, in Pittsburgh, in Christchurch, in Poway, El Paso, and in the many other instances of violence that have unfolded over the last few months in particular. The greatest threat to our country right now is white supremacist and other far-right domestic terrorism. And we need to acknowledge that. The facts continue to back that up, and attempts to deflect and distract from that, as our government has been doing, DOJ and the White House in particular, are just dangerous. I think many have also probably seen the report that came out last week about the Department of Homeland Security whistleblower report, which paints in excruciating detail how Trump appointees sought to force DHS to downplay the threat of white supremacist terror and add in fairly non-existent threats from the left to a report on extremism. That is a sadly perfect metaphor for so much of what is happening right now. And while, again, of course, there is violence that comes out of the left, it is not the same. We shouldn't be creating a situation in which in which there is any form of equivalency between the two sides, and our failure to acknowledge the direct, dire threat of white supremacist terror in this country is incredibly dangerous. So I do think it's so important that we recognize that and focus on that. Someone asked about potential actions by the government that might target civil rights groups, other groups. In particular, I think this is a debate that's happening right now around this question of whether there should be a domestic terror statute in the United States currently. There is no domestic terror statute in that if you are, for example, a white supremacist domestic terrorist who shoots up a Walmart in El Paso or somewhere else, you can't be prosecuted as a terrorist. In the same way that, say, a Islamic terrorist can. There is a large debate happening around whether we should change our statute, change our laws. And one of the biggest concerns that I agree is a very real concern is the ability of DOJ and other sort of governmental infrastructure using a domestic terror statute like that to go after groups like Black Lives Matter, or quote unquote Antifa, which is not an organization at all in any way, shape, or form, despite the fact that Trump and DOJ are trying to paint it as such. And there is a very real concern that creating a domestic terror statute might allow for the targeting of groups like Black Lives Matter as quote unquote domestic terrorists, the same way that far right governments have previously tried to target civil rights groups. So that is something that as we consider how our policies, how our statutes, how our laws might change to account for the threat of domestic terror and white supremacy, we also have to be cognizant of the unintended consequences and not give extremists in our own government the tools to take on civil rights groups and others that are certainly not the equivalent of the white supremacist groups and leaders we are trying to take on here.
Great, thank you, Amy. And we have about 3 minutes left, so I'm going to combine parts of two questions into one as a final questions for you. One is, to what extent do you think the use of social media makes it possible and easier for isolated individuals to join these groups and jump from ideology to action? And the flip side of it is another question is, are you afraid that your lawsuit and others like it will only silence these hate groups while they work less overtly? In other words, drive them underground so you can see them less.
Good questions. To start with the first, I think absolutely social media has made it far more possible for these groups to recruit, to have to sort of have disaffected individuals find extremism online, connect with it, and then turn that ideology into an action, as the questioner asked. I think I said earlier in the past, for example, when the KKK Act, which is the statute we're using, was passed, you were dealing with Klan groups that were relegated to specific areas that would operate in their communities. And while it was horrific and awful in so many ways, it was relegated to a very specific area. Now these extremists are able to connect no matter where they are, find equal like-minded people around the country, and using social media, turn that ideology into action, as we saw again from Charlottesville to Pittsburgh to Christchurch to Poway to El Paso, in which each one of those attacks was used to inspire the next one. And of course, now when we see car attacks that are directly inspired by what happened in Charlottesville, and that have been happening at a frightening pace over the last few months. So the short answer is absolutely, and it directly ties into what we were talking about earlier about the need to figure out a solution to address the role of social media here. The second question about whether this might force groups to work less overtly, push them back underground. I do hope that this pushes them back underground. I do think that we are already seeing the deterrent effect here, and that while we will never fully eradicate hate and we will never fully eradicate violence. We are making clear that there are very real consequences for being part of this violence, for being part of these conspiracies. And that by holding them accountable, we are already seeing a number of these groups try to, rebrand. Some of them try to claim that they're leaving the movement. Others complaining that they can't go about their business because of this. And that means that it's working. A number of them have talked, and I apologize if you hear my dog barking. He is equally incensed about the rise of extremism in this country. A number of the defendants and others in our suit, as I mentioned earlier, have talked about how this suit has really served as a deterrent, how they don't want to be sued, so they're not going to return to Charlottesville for another Unite the Right or something along those lines. And this case has been cited in a number of instances in which larger scale events were canceled because of the deterrent effect that this poses. So yes, I do think that it's important that we try to push these people back underground where they belong. And that doesn't mean simply so that they can continue their activities, but by bankrupting them, dismantling them, and showing them the very real consequences for these actions, we will hopefully also ensure that they sort of stick to their chat rooms and don't turn that into real world action.
Great. Thank you, Amy. Thank you so much for spending an hour with us and educating us and the important work that you're doing. And to people's questions we couldn't get to today, I'm sorry, but you can email me those questions too, and I will see if I will be sharing them or answering them or sending them on to Amy as appropriate. And I will send out a follow-up email tomorrow with information about the lawsuit. I know there are students on this webinar too, so if you have any questions, please, I encourage you to email me too about that, even if you didn't put a Q&A. And again, thank you, Amy, for your important work, and thank you, everybody, for spending an hour with us as we got educated about this important lawsuit. We wish you the best of luck.
Thank you so much.
Thanks, everybody. Take care. Have a good afternoon.